So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about firing someone in Venezuela. Yes, that's right. It's another comparative HR that I'm going to be doing today. You may or may not know Venezuela is a fairly large oil producing country in northern South America. It is communist, which will make this a little bit interesting, I think, and something worthwhile, worth talking about. This article is from Denton's, and they're an international employment law firm. But we'll go over it, and there's a lot of interesting things that come with labor law in Venezuela. So let's talk about it. There is a bar against dismissal where no employee can be fired without just cause as authorized by the labor inspector's office. Now, in many countries, especially in Europe, you can fire someone and then you'll need to let the labor inspector's office know. But it's a little different here in Venezuela. You actually have to have it approved by the labor inspector's office. And the labor law is created so that you keep employment and prevent lockouts and reductions in personnel. And so they can intervene in a company's operations when there's a chance that it may be closed, that there may be a reduction of personnel, or that there may be a change in labor conditions. And so if an employer just closes a company, they could get in a lot of trouble, and the ministry can take over the company's operations to protect the rights of the employees, which is, I mean, fine. Assuming you know what you're getting into, but that will start all sorts of problems, right? Governments will be, or governments do in Venezuela, operate failing companies just for the sake of keeping people's jobs, and I imagine they don't imagine they're not very good at running those businesses. So incredibly interesting, and failure by company management to resume operations may go to jail. Everything is straight to jail, just like the Parks and Rec dictator, right? And the only exception is that upper management employees and those hired for an undefined term with less than 1 month of service, no employee may be dismissed without just cause. And here's a list of the just causes. They're the definitions. And I mean, it is pretty broad. I'm curious you have to prove these, and we'll talk about that a little bit later. But I'm curious about exactly how much you have to prove. But they include, just cause includes dishonest or immoral behavior while at work, violence, causing injury, negligent acts, omissions or imprudent acts, unjustified absence from work for 3 working days in 1 month, which I'll be honest, that's kind of hilarious because there are many companies in the United States that will not fire you for 3 working days in 1 month, but in Venezuela, that is justified dismissal, right? And I am curious what unjustified absence means. I mean, is it acceptable, for example, to be late because there's a lot of traffic? What does that look like? Whether or not you reveal the employer's secrets, which is kind of interesting because if the business fails, the secrets will be just revealed to the government, I imagine, as well as serious violations of the obligations imposed by a labor relationship, abandonment of work, and bullying, harassment. So these are all things that are justified dismissal, which I mean, all seem to be relatively, they make sense. It makes sense for the most part, although again, you can't fire anyone without these. The employee has 1 month to request reinstatement and payment of unpaid salary before they get reinstated. And frankly, that is pretty short. Many of the discrimination statutes have a much longer timeline for reinstatement or to be paid. Now, granted, this is specifically surrounding unjustifiable dismissal, but that is the case. I mean, in much of from federal law, I believe you have a lot more time than than 1 month to file a claim. And if an employer doesn't get the permission to fire someone, then the employee can be reinstated. And if you don't hire them back, 6 to 15 months in prison. This is incredible. I think it's a lot of fun to read this, although I feel bad. I don't know. I mean, this is one of the many reasons why Venezuela is having a tough time in the labor market. You're going to jail if you don't rehire a person within 6 to 15 within the time frame. If you don't rehire someone, you're going to jail for 6 to 15 months. Why would you ever start a business if everything was dictated for you and failing to comply resulted in jail every time? Now, there are some circumstances in the United States where you might end up going to jail, but it doesn't seem unjustified dismissal seems to be a lot broader. I also would hate to be the person who gives approval for these terminations because the whole town must just hate you or the whole region or whatever. Um, and so there are ability for redundancies, and which that's the also called layoffs in American English. And whenever an employer wants to lay people off, even if the employer cites technical or economic reasons, that will be subject to judgment. And when you need to lay off, you have to give notice to the respective labor union or the employees themselves. And a layoff may be subject to arbitration, regardless if there's a union or not. And as a result, employers cannot freely dismiss employees without just cause and without previously obtaining authorization. And so there's really a redundancy is pretty difficult to take place here. In cases of mass layoffs, Ministry of Labor can stop you from doing mass layoffs, and it's one where it's more than 3 months, and it's either 10% of the workforce that of a company that has more than 100 employees, 20% of a workforce for a company that has more than 50, or 10 employees of a company with fewer than 50 employees. And the labor inspector may conduct a study, and you can't necessarily just do it because there's a request. And the declaration of the Ministry of Labor is based on reasons of social interest. And so as a result, an employer can't just simply dismiss everyone. It's not allowed. They have to have it considered, and then it's a matter of social interest of whether or not it's even approved. And so that's really critical to understand and really unique. And so what happens is that when this happens, when mass redundancies happen, when mass layoffs happen, the labor inspector has to give a report to the Ministry of Labor. And if a mass layoff is determined, the Ministry of Labor can order the reinstatement of former employees and the payment of their lapsed salary. So if you laid everyone off, depending on the Ministry of Labor, they could require everyone to come back. In addition, it must be initiated before the labor inspector's office, and they can request a reduction of personnel based on ongoing economic circumstances, but it would be subject to analysis, and that's the biggest thing. And so ultimately, in addition, they can require any supporting documents to prove that you actually need to lay these people off and get expert opinions. That seems like a lot. Ultimately, if the government disagrees, a conciliation board is made up of 2 representatives and 1 deputy for each delegation to go over the dismissal procedure. And the recommendation of the conciliation board may contain specific agreements on settlements. And the conciliation may agree to, amendment of job conditions in the CBA, collective suspension of work for no more than 60 days, during which time the employees will not be required to render their service and employer will not be required to pay. In addition, they could, and this is kind of interesting, but they could initiate a recapitalization and reactivation process for the company with the participation of the employees under the concept of co-management. So here, to recap here, the government would I assume the government, it doesn't quite say, but the state will help with obtaining credits under preferential or government subsidized conditions. So what could happen is if the business is failing, the government may bail them out, and it'll be a co-management, and the employees will be involved with it. They could also get tax benefits and so forth. That happens in the United States, generally speaking, only with respect to employers who are deemed critical. This doesn't quite say whether or not that's the case. But they're only fully able to terminate the relationship between the employee and the employer through a written settlement agreement containing a detailed report of the events causing the termination. So that's it. That's a really interesting concept. It's very involved, and you can see why people might not be interested in starting a business in Venezuela. That seems to be a little bit much, but who am I? I'm not running it. And, oftentimes I think that making these types of judgments is simply a form of colonialism. Let me know what you think in a comment down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.